Welcome to Literary and Jury Charge Practice. Let's start out with this closing argument. Ready? Here we go. If you want to know why the defendant committed these crimes, that's the question Ms. Clark just told you can't be answered. If you want an explanation of how he became this person, of what made him do it, what better place to look for the answer than in his own handwritten explanation of his actions? He wrote in the boat, "I'm jealous of my brother who has received the reward of martyrdom, but God has a plan for each person. Mine was to hide in this boat and shed some light on our actions. God has a plan for each person." That's who he believed he was doing this for. His God, not Tam Sarnev. He wrote, "He who Allah guides, no one can misguide." Again, that's who he believed was guiding him, Allah, not his brother. He wrote, "The U.S. government is killing our civilians. As a Muslim, I can't stand to see such evil go unpunished." He's talking about himself. He doesn't even mention his brother. He also wrote, "Now I don't like killing innocent people. It is forbidden in Islam, but in this case it is allowed. Again, I don't like killing innocent people." He's talking about himself. His tweets are the same. They give the reasons. They give his reasons for believing in violent jihad. Those tweets never even mentioned his brother. In the end, the best evidence you have of the nature of the defendant's relationship with his brother Tam is the evidence of how they actually committed these crimes. They committed them together as partners. Each one had an essential role to play. Tam was ready to commit violent jihad as early as January 2012 when he left for Russia, but the defendant wasn't ready yet. He was reading terrorist writings and listening to terrorist lectures, but he wasn't yet convinced. So Tam left for Russia, hoping to find a partner there. He came back when he didn't succeed, but by then the defendant had steeped himself in the writings of Inspire and Anwar, and he had become inspired himself. He decided he was ready to partner up. It was only then, when the defendant made the decision to become a terrorist, that Tam was able to go into action. The defendant obtained a gun and ammunition, a crucial ingredient in their plans. He arranged for them to go to the range in Manchester to practice firing it. When Marathon Monday arrived, he let Tam go on ahead to the finish line, and when he chose on his own where to place his bomb for maximum effect, then he called Tam to give him the go-ahead. Again, contrary to what Ms. Clark just told you, later on April 19th, both of them executed Sean Collier. There's no evidence of who pulled the trigger. You know that Sean Collier's blood was found on the defendant's keychain and on the gloves that were on the floor of the car by his feet, but the video doesn't show who pulled the trigger. Don't mistake argument for fact. It was a full-on partnership, a partnership of equals. They did not do the exact same things, but they were both terrorists engaged in a joint effort. They bear the same moral culpability for what they did together. The very first mitigating factor on the defense list is that the defendant was 19 years old when he committed these crimes. In fact, he was just shy of 20. What about that fact? And what about the fact that some of the time he still acted like a teenager doing teenage things? Is that a mitigating factor that deserves any weight? It might deserve some weight if these were youthful crimes. For example, if the defendant and his brother had robbed a liquor store and shot the clerk in a moment of panic, but these weren't youthful crimes. There was nothing immature or impulsive about them. These were political crimes designed to harm the United States, to punish Americans for our military actions overseas by killing and mutilating innocent civilians on U.S. soil. They were acts of terrorism planned over a period of months and carried out over days. They were acts of terrorism so successful that they not only killed 4 people and maimed 17 others, but stopped the Boston Marathon, closed Logan Airport, and shut down the entire city of Boston for nearly a day. The murders on Boylston Street were not a youthful indiscretion. The cold-blooded execution of Sean Collier, a police officer, was not a rash or impulsive act. The defendant was old enough to understand right from wrong. He wrote in the boat, "I don't like killing innocent people, but in this case it is allowed." He decided that the cause of his people, the Ummah, justified the murders of a small child, 2 young women, and a police officer. Does being nearly 20 years old mitigate any of that? Ms. Clark said at the beginning of her closing that these crimes were senseless, but they made perfect sense to the defendant, and he was perfectly able to imagine the harm his actions would cause. He was certainly old enough for that. Mr. Mellon already talked at length about ADX and the SAMs. I'm not going to repeat what he said. I just want to emphasize one point that every witness who testified agreed upon. There is no guarantee that the defendant will spend the rest of his life in H unit or even in ADX. In fact, the opposite is true. BOP tries to step down inmates whenever possible, and BOP's desires are taken into consideration whenever SAMs are up for renewal. Even if everyone in the government wanted the defendant to stay on SAMs, there are legal requirements for keeping them in place. If those requirements are not met, the SAMs can't be renewed. There has been litigation over SAMs. Will the defendant spend the rest of his life on H unit or even in ADX? He has not proved that to you because he can't. Let's talk for a minute about Sister Helen. Why did the defense choose her over all other clergy who could have been invited to spend time with the defendant and then testify about it in court? Why not call in Imam from the mosque here in Cambridge, like Mr. Asaf, who testified here in court? Why bring in someone from Louisiana? Do you think it has anything to do with the fact that Sister Helen is one of the leading death penalty opponents in the United States? Did Sister Helen's testimony really give you much insight into what the defendant really thinks and believes? Put aside for a moment that as a nun she undoubtedly tries to see the good in everyone, and put aside that as a committed opponent of the death penalty she undoubtedly wants to help the defendant avoid it. Focus instead on what she told you the defendant actually said to her. What do those words really mean in the end? They're open to a lot of interpretation, and because of that, they really don't tell you anything at all. In the end, can you be confident that you really know more about the defendant now than before Sister Helen testified? According to Sister Helen, the defendant said no one should have to suffer like that, but he expressed pretty much the same sentiment in the manifesto he wrote in the boat. He wrote, "I don't like having to kill people," but he went on to say that sometimes it is necessary to kill people to advance the cause of the Muslim people. That's a core terrorist belief. The fact that now, while he's on trial for his life, the defendant is willing to go so far as to say that no one should have to suffer like that doesn't tell you much about his core beliefs. When you stack that up against his actions in this case, does it really make a difference to your decision? Sister Helen said that the defendant seemed young to her, and Ms. Clark tries to spin that into a guarantee that the defendant will become remorseful over time, but there's no evidence of that, no reason for you. Sister Helen is 76 and the defendant is 21. Of course, he seems young to her. What did their brain development expert, Dr. Guide, tell you? He testified that in determining a person's level of maturity, the single most important thing to look at is his behavior. He told you that some people are more mature at age 19 or even age 14 than some adults will ever be. And he told you that there is absolutely no guarantee that a 19-year-old will get any more mature or reflective just because his brain will continue to grow over time. Ms. Clark criticizes the government for showing you the image of the defendant in the holding cell, giving the camera the finger rather than showing you the whole video, but the whole video is even worse. It shows you just how remorseless the defendant was when he came into court to answer for his crimes 3 months after committing them. Mr. Bruck said in his opening that if you sentence the defendant to life, he'll spend the rest of his life thinking about his crimes, but that's not true just because the defense says it is. Where's the evidence of that? If the defendant goes to prison for life, he won't be free to come and go, but he will be safe, well fed, and have excellent medical care. Will he spend his days thinking about the victims, or will he spend the rest of his life thinking about himself, his family, his friends, his pen pals, his next workout, his next visit, his next phone call, his next meal? Will he stare at the wall all day, thinking about the pain and suffering he has caused, or will he do many of the very same things that people do every day to enjoy life, read books and magazines, talk on the phone to his parents, his sisters, and his friends, eat, pray, sleep, exercise? Maybe he'll even write a book. You saw from the evidence what kind of a person he is. Maybe he'll leave behind his memories of Martin, Richard, Crystal, and Ling Lu in the same way he left them dying on the street when he went shopping at Whole Foods. Maybe he'll leave behind his memories of Sean Collier the same way he left him bleeding to death in his patrol car as he drove into Boston to look for another gun. The indifference that allows you to destroy people's lives, to ignore their pain, to shrug off their heartbreak, that doesn't go away just because you're locked up in a prison cell. It's what enables you to be a terrorist, and it's what insulates you from feelings of remorse. In the end, did you hear any testimony from any witness that speaks louder about the appropriate punishment in this case than the defendant's own actions on Boylston Street or at Whole Foods or at MIT or on Laurel Street? The defendant deserves the death penalty, not because he's inhuman, but because he's inhumane, because of his willingness to destroy other people's lives for an idea. Most people can't even imagine standing for 4 minutes behind a row of children, sometimes only feet away from them, and leaving behind a bomb that you know will cause them excruciating pain and a lingering death on the sidewalk. But that's what it is to be a terrorist. If you want to know who the defendant was, you have the testimony of his relatives, his teachers, and his friends. But if you want to know who he turned into, look at his actions. They tell you all you need to know about the kind of person he became. His actions on Boylston Street, afterwards at Whole Foods, at MIT, and in Watertown, and in this courthouse on the day of his arraignment, they are the best evidence you have about who the defendant became. Ms. Clark urged you to just go through the intent factors and the aggravating factors in the verdict form and just check them off. I urge you to take your time with each one and give it the consideration it deserves. As for the mitigators, she urged you to go through them one by one and just fill in 12. But you only write in 12 if all 12 of you find a mitigator to be proved. One final thought before I sit down. If you sentence the defendant to life imprisonment, you will be giving him the minimum punishment authorized by law for these crimes. Contrary to what Ms. Clark said, it is a lesser punishment than death. Does he deserve the minimum punishment, or do these crimes, these 4 deaths, demand something more? Please ask something yourself that question when you go back to deliberate. Thank you. All right, let's try some jury charge practice. Ready? Here we go. Members of the jury, I will now instruct you on the law that you must follow in deciding this case. Each of you has a copy of these instructions to use in the jury room. You must follow all of my instructions about the law, even if you disagree with them. This includes the instructions I gave you before the trial, any instructions I gave you during the trial, and the instructions I am giving you now. As jurors, you have 2 duties. Your first duty is to decide the facts from the evidence that you saw and heard here in court. This is your job, not my job or anyone else's job. Your second duty is to take the law as I give it to you, apply it to the facts, and decide if the government has proved the defendant guilty beyond a reasonable doubt. You must perform these duties fairly and impartially. Do not let sympathy, prejudice, fear, or public opinion influence you. In addition, do not let any person's race, color, religion, national ancestry, or gender influence you. You must not take anything I said or did during the trial as indicating that I have an opinion about the evidence or about what I think your verdict should be. The charge against the defendant is a document called an indictment. You will have a copy of the indictment during your deliberations. The indictment in this case charges that the defendant committed the crime of conspiring to act as an agent of the Republic of Zimbabwe, knowing acting as an agent of the Republic of Zimbabwe and willfully conspiring to provide services to specially designated nationals Robert Mugabe, Gideon Gono, and other Zimbabwe officials. The indictment is simply the formal way of telling the defendant what crime he is accused of committing. It is not evidence that the defendant is guilty. It does not even raise a suspicion of guilt. Defendant denies the allegation in the indictment. The defendant is presumed innocent of the charge. This presumption continues throughout the case, including during your deliberations. It is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty as charged. The government has the burden of proving the defendant's guilt beyond a reasonable doubt. This burden of proof stays with the government throughout the case. The defendant is never required to prove his innocence. He is not required to produce any evidence at all. You must take your decision based only on the evidence that you saw and heard here in court. Do not consider anything you may have seen or heard outside of court, including anything from the newspaper, television, radio, the internet, or any other source. The evidence includes only what the witnesses said when they were testifying under oath, the exhibits that I allowed into evidence, and the stipulations that the lawyers agreed to. A stipulation is an agreement that certain facts are true or that a witness would have given certain testimony. Nothing else is evidence. The lawyer's statements and arguments are not evidence. If what a lawyer said is different from the evidence as you remember it, the evidence is what counts. The lawyer's questions and objections likewise are not evidence. A lawyer has a duty to object if he thinks a question is improper. If I sustain objections to questions the lawyers asked, you must not speculate on what the answers might have been. If during the trial I struck testimony or exhibits from the record or told you to disregard something, you must not consider it. Give the evidence whatever weight you believe it deserves. Use your common sense in weighing the evidence and consider the evidence in light of your own everyday experience. People sometimes look at one fact and conclude from it that another fact exists. This is called an inference. You are not allowed to make reasonable inferences so long as they are based on the evidence. You may have heard the terms direct evidence and circumstantial evidence. Direct evidence is evidence that directly proves a fact. Circumstantial evidence is evidence that indirectly proves a fact. You are to consider both direct and circumstantial evidence. The law does not say that one is better than the other. It is up to you to decide how much weight to give to any evidence, whether direct or circumstantial. Do not make any decisions simply by counting the number of witnesses who testified about a certain point. What is important is how truthful and accurate the witnesses were and how much weight you think their testimony deserves. Alright, and now for some literary practice. And this is an article we had started previously called Stepping into Retirement. Ready? Here we go. Some agency owners, officials, freelancers, and captioners choose to ramp down their workload over a few months or a few years, giving themselves the opportunity to continue to earn some money and yet being able to split their time between personal goals and keeping a hand in the profession. Stepping back from a full workload can allow personal goals to become more of a priority, even as they kept work on their schedule. In the meantime, knowing what your personal plan for your time is, whether it's travel, volunteering, spending time with grandkids, pursuing a hobby, or working on a personal passion that took a backseat during your career, can help keep you inspired as you save toward your goal. A potential concern is how to leave the work itself behind. For some, that means finding a replacement or handing over a business they've spent years building. My first concern was to find an ethical firm to take over my business. My second concern was to ensure that my staff and my core reporters had a position with the new firm and that they would be treated fairly. I didn't expect lots of money from the sale, so I was not relying on that for my retirement, said Everman. For others, it's about finishing up the last few days, weeks, months, or years of transcripts. Several people noted that they set aside a certain amount of time to produce transcripts so that if they did receive calls, the transcript was ready to be sent out when asked. While this means that you may not get into retirement mode immediately, this can also alleviate some of the concerns about keeping up to date with computer software and hardware into retirement, especially if that aspect is one you want to avoid. I copied my important files into an external drive, such as my case catalyst files, personal dictionary system files, says Martin. I had to also pull off personal files from the hard drive since I would be leaving the computer behind. I decided to buy a refurbished replica computer of the one I used at the IMF, and now that I got it, I've got the files from the external device and feel that I'm ready to move on completely. A few mentioned that they continued taking work, but on a reduced basis before going into a full retirement from work, which helped them keep up with transcripts. If you plan to keep a hand in professionally, especially as an agency owner or an official, consider offering to train or mentor reporters as you start to reduce your time working. You might also consider working with a reporter or scopist who can make getting through the backlog of transcripts a relatively quick and easy experience. All right, we will stop there, and that will conclude our literary and jury charge practice.